my name is Lizette Lagunas, and this is my Week 6 presentation where I will be discussing 4 different alternative dispute resolutions and comparing this week's reading with some peer-reviewed journals. I will also be discussing a new story about Comcast, a Vermont access network, using early neutral evaluation in a settlement case. Let's get started. According to this week's reading, when using early neutral evaluation, E&E, the court appoints a third party who is neutral and is knowledgeable about the subject that is being disputed. Then the mediator is to listen to the facts and provide their own legal opinion, but it is not necessarily binding. According to the peer-reviewed journal on E&E for child custody and parenting, the cases seem to be becoming more successful in resolution approaches, with majority of cases actually reaching in early settlement by using E&E. According to the journal, it also reduces stress and expenses of custody disputes. This week's reading and the journal relate because they both mention having an appointed third party, which is neutral. They both discuss confidentiality and the importance of it and receiving feedback from the mediators. The journal puts into perspective the vulnerability of those that go into trial for cases like this and how E&E can allow focus of each parent or each party in any other case without focusing on deficits of the other and not reinforcing conflict, and it actually decreases animosity. According to this week's reading, using Dispute Review Board as an ADR is appropriate when using projects that involve like high risk and possibly liability, and it is actually composed of a panel led by a professional, and they are chosen by both parties. It is also important because it bridges the communication amongst parties throughout the project, which eventually saves money and time. Journal analysis of construction dispute review boards. The authors discussed the contracts dispute procedure that contained 4 steps, which were really interesting. They included like negotiation before the dispute review board, the initial meeting, then a consensual resolution during mediation, which they hope for. The similarities between the journal and the readings is the emphasis that is placed on creating almost perfect contracts before the project, and the importance of knowing boundaries and expectations before the project. So if using dispute review boards, the before work is far more important than work during the review board. Well, alongside both are really important, but the before work is extensive. Again, I think the journal was great to present the real life scenario when using DRB and the amount of work that is needed before beginning, like I mentioned, and a huge construction project, and also the tactical use of individuals in the dispute board is also important. According to the book, mini trial is voluntary, and although non-binding, it is still structured. And although it can be more expensive than other ADRs, it is cheaper than litigation because they have mediators that have a pretty good reputation, like attorneys or retired judges. And according to the book, they have a panel of 3 people, 1 for each disputant, and then a neutral one. But according to the journal on mini trial that I found, the process is more of a negotiated settlement, not really a mini trial. And it can only be successful when there is mutual agreement, and it takes time to prepare. Usually a senior manager holds the responsibility of preparing, and it takes a lot of time. And some of the similarities between the journal and the readings were the emphasis on how the method is more costly than others, but it is cheaper than litigation once again. There is also a concern that because it is not an actual trial, there's no protection against lying when people are presenting like their case, and it can be risky. So that is what I learned from the journal. Last ADR that I will be discussing is summary jury trial, which is pretty much a non-binding trial, and it is done before actually going to trial. And from what I could understand, it's pretty much like a practice trial. It's just on a clear schedule. Like they are allowed 15 minutes for opening statements, 1 hour for presenting the case, half an hour for rebuttals, and it just saves time during the trial. Pretty much that's the objective. Even the objections are solved before the trial when using summary jury trial. A brief deliberation, and then there are post-trial settlement conferences. So it really is a summary of the jury trial, but it is done previous to the trial. In a journal that I found by Avern Khan, she speaks about how some of the summary jury trials are actually mandated by judges before going to trial to save time. What I learned from the article, though, is that summary jury trials should really be voluntary because you put jurors in a position where they're making a decision, but their decision does not 100% weigh in the ultimate final binding decision. So the journal really focuses on that it should be voluntary and it just doesn't drag on for if they can't come to a conclusion. So the news story that I found was a civil lawsuit that was filed by the Public Service Board against Comcast, which is a networking cable company. And what I found interesting was that the suit was filed because Comcast was actually not looking out for the patrons, and it was not meeting community needs and interest. And that is why the judge ordered an early neutral evaluation of the case. And I remember that the book said it prevents unnecessary planning for litigation of a case. And that is exactly what the news article said, that it gave Comcast a way of seeing and understanding why their permits weren't being renewed and why they were actually being held accountable for a civil suit. They were able to see the actual cost of them going to trial and how their actions were actually affecting an entire community not being able to stay connected and not have cable anymore because they were actually monopolizing the cable companies to just benefit them. It gave them an opportunity to resolve this case before even going to trial, which saved them a lot of money in the long run. And that is why I thought that this story was so interesting, because it solidified everything that I had read for this week. And that is my presentation for the week. I will see you guys next week.